If you've been waiting for your green card and wondering what March 2026 might bring, I need you to pay close attention to the next few minutes because what I'm about to share could directly affect your immigration journey. I'm your host at Immigration News Today, and today we're diving deep into what we know about the March 2026 Visa Bulletin, what the February data tells us, and exactly what steps you should be taking right now to protect your place in line. Whether you're in an employment-based category, family-sponsored preference, or you're tracking the diversity visa program, this video is packed with actionable information you can use immediately. So let's get started. Now, before we go any further, I want to be completely transparent with you. As of February 11th, 2026, the official March Visa Bulletin from the Department of State has not yet been published. Typically, the State Department releases each month's bulletin around the 8th to 12th of the preceding month, so we're right in that window. What that means is we're working with the most recent official data from the February 2026 Visa Bulletin, combined with expert analysis and historical patterns to give you the clearest picture possible of what March might hold. Immigration policy can change, and the information I'm sharing today is current as of this recording date. But you should always verify the latest updates on the official Department of State website at travel.state.gov and consult with a qualified immigration attorney for your specific situation. This content is informational and educational, not legal advice. Let's talk about what we know from February 2026 and what that tells us about where things are heading. The February Bulletin, officially released in early January by the Department of State's Consular Affairs Office, showed some interesting patterns that are worth understanding. For employment-based categories, we saw modest forward movement in certain areas, particularly for EB3 Rest of World, which advanced about 40 days in the final action dates. Meanwhile, India and China EB categories remained largely frozen, continuing a pattern that's been in place for several months now. For family-sponsored categories, Mexico saw notable advancement, with F1 Mexico moving forward approximately 112 days and F2B Mexico advancing 92 days. These movements matter because they tell us about demand, supply, and how the State Department is managing the annual numerical limits set by law. Here's what you need to understand about how this whole system works. The United States has statutory limits on how many immigrant visas can be issued each fiscal year. For fiscal year 2026, which runs from October 1st, 2025 through September 30th, 2026, the family-sponsored preference limit is 226,000 visas, and the employment-based preference level is at least 140,000. On top of that, there's a per-country cap, which means no single country can receive more than 7% of the total family and employment preference visas in a given year. That 7% figure works out to about 25,620 visas per country. This is why applicants from high-demand countries like India, China, Mexico, and the Philippines often face much longer waits than applicants from other parts of the world. It's not about the quality of their applications or anything they did wrong. It's simply mathematics and statutory limits. Now, let's break down what experts are predicting for March based on February's data. According to analysis from immigration law firms and visa bulletin tracking services, the expectation for March 2026 is conservative to modest movement in most categories. For EB1 worldwide, we might see minimal movement or the category holding steady, as demand has been moderate. EB2 and EB3 for India and China are expected to remain largely stagnant or move very slowly, perhaps just days forward if at all. EB3 for Rest of World, Mexico, and Philippines could see continued forward movement, possibly another 30 to 50 days, though that's a prediction, not a guarantee. For EB5 investors, the regional center and set-aside categories like rural, high unemployment, and infrastructure are expected to remain current, meaning anyone with an approved I-526 in those categories should have a visa number available. On the family side, the predictions suggest F1 worldwide might advance modestly, perhaps 30 to 60 days. F2A, which is for spouses and children of green card holders, has historically been volatile, and March could see either advancement or a holding pattern, depending on demand. F2B, F3, and F4 categories are expected to move slowly for most countries, with Mexico continuing to see better movement than other regions due to per-country cap dynamics. For the Philippines, the wait times in family categories remain among the longest in the world, particularly for F4, the brothers and sisters category, where applicants are looking at wait times exceeding 20 years. Let me talk about something that often confuses people: the difference between final action dates and dates for filing. The Visa Bulletin publishes two charts for both family and employment categories. The final action date, also called the application final action date, is the date that determines when you can actually be issued an immigrant visa or approved for adjustment of status to become a permanent resident. Your priority date, which is the date your petition was filed or, in some cases, your labor certification was submitted, must be earlier than or the same as the final action date for your category and country. The dates for filing chart, on the other hand, tells you when you can submit your Form I-485 Adjustment of Status application to USCIS if you're already in the United States. USCIS announces each month which chart you should use for filing purposes. For February 2026, USCIS instructed applicants to use the dates for filing chart for both family and employment categories. That could change for March, so you'll need to check the USCIS website at www.uscis.gov/visa-bulletin-info to confirm which chart is in effect. Here's what you should be doing right now, regardless of where you are in the process. First, know your priority date. If you don't know it, find it immediately. For employment-based cases, it's usually the date your perm labor certification was filed, or if no perm was required, the date your I-140 petition was filed. For family cases, it's the date your I-130 petition was filed. This date never changes, and it's your place in line. Second, check the Visa Bulletin every month. Set a reminder on your phone for around the 8th to 15th of each month to check the Department of State's website for the new bulletin. Third, make sure your address is updated with USCIS and with the National Visa Center if you're processing through consular processing. If you move and don't update your address, you could miss critical notices. Fourth, if your priority date is getting close to being current or is already current, make sure all your documents are ready. That means a valid passport, medical examination completed if required, financial documents for the affidavit of support, police certificates if needed, and any other country-specific requirements. Let's talk about what current means because this is important. When a category is listed as C for current in the Visa Bulletin, it means that immigrant visa numbers are available for all qualified applicants in that category, regardless of their priority date. You don't have to wait. Categories that remain current for extended periods include immediate relatives of U.S. citizens, such as spouses, parents, and unmarried children under 21, which are not subject to numerical limits, and also certain EB-5 set-aside categories that we mentioned earlier. If your category becomes current, that's your green light to move forward, but you still need to make sure you're documentarily qualified and that you follow the proper procedures. Now I want to address something that's causing anxiety in the immigrant community: the uncertainty around potential policy changes. We're in February 2026, and immigration has been a topic of significant policy discussion. What I can tell you is this: the Visa Bulletin system is governed by the Immigration and Nationality Act, which is federal law passed by Congress. While executive actions and agency policies can affect processing times, priorities, and certain aspects of implementation, the fundamental numerical limits and per-country caps are set by statute. That means they would require congressional action to change. Does that mean things won't change? No. Immigration law has been amended many times throughout history, but it does mean that the basic framework we're discussing today is relatively stable compared to other aspects of immigration policy. What you can control is making sure your case is properly documented, that you respond to any requests for evidence promptly, and that you're working with qualified legal counsel if your case is complex. Let me give you some real-world scenarios to help this make sense. Imagine you're an EB-2 India applicant with a priority date of January 1st, 2015. You've been waiting over 10 years. You check the February 2026 Visa Bulletin and see that the EB-2 India final action date is April 1st, 2013. Your date is not current yet, but you also see that the EB-2 India dates for filing is June 15, 2013, and USCIS is allowing filing based on that chart. You're still not current for filing either. What should you do? First, don't lose hope. Continue monitoring the bulletin monthly. Second, consider whether you qualify for EB-3 downgrading, which is a strategy some EB-2 applicants use if EB-3 dates are more current. Third, make sure your employer is still willing to sponsor you and that the job offer is still valid. Fourth, consult with an immigration attorney about your specific options, because there may be strategies available based on your individual circumstances. Here's another scenario. You're an F2A applicant from Mexico with a priority date of March 1st, 2023. The February 2026 bulletin shows F2A Mexico at January 1st, 2023, and your date is not yet current. However, F2A has historically been volatile, sometimes jumping forward several months or even becoming current, and other times retrogressing backward. What should you do? Monitor the bulletin monthly, but also be prepared for the possibility that when F2A does advance or become current, you'll need to act quickly. Have your documents ready, including a valid passport for your spouse or child, medical exam appointments scheduled or available to schedule quickly, and financial support documentation prepared. F2A cases can move fast when they do move, and you don't want to be caught unprepared. For diversity visa selectees, your situation is different. If you were selected in the DV 2026 lottery, you have until September 30th, 2026 to complete your immigrant visa process and be admitted to the United States. That deadline is firm and cannot be extended. The February 2026 bulletin already published the DV cutoff numbers for March, and these are official numbers, not predictions. For March 2026, DV numbers are available for certain case numbers in each region: Africa, Asia, Europe, North America, Oceania, and South America. If your case number is below the cutoff for your region, you can proceed with your processing. If it's above the cutoff, you'll need to wait for future bulletins. However, and this is critical, the Department of State has warned that DV visa availability through the very end of fiscal year 2026 cannot be taken for granted, and numbers could be exhausted prior to September 30th. What that means in plain English is, don't wait. If you're a DV selectee, proceed with your case as quickly as possible. Submit your DS-260 form, gather your documents, schedule your interview, and complete the process. Every month you delay is a month closer to that September deadline, and there's no guarantee that visas will be available in the final weeks. Let's address the employment fourth preference religious workers category, because there's been a significant development. The SR category, which is for certain religious workers in non-minister roles, was extended by Congress through January 30th, 2026. No SR visas can be issued overseas, and no final action can be taken on adjustment of status cases after midnight on January 29th, 2026. For February, the category was listed as unavailable, and it's expected to remain unavailable for March 2026 unless Congress passes new legislation extending it again. If you're a religious worker in the EB-4 category, you need to stay in close contact with your immigration attorney and your religious organization to understand your options, which may include other visa categories or a potential future extension if Congress acts. Now, let me be very clear about something. Visa Bulletin predictions from any source, including the ones I've mentioned, are exactly that. Predictions. They're educated guesses based on historical patterns, demand data, and expert analysis, but they are not official. The only official source for visa cutoff dates is the Department of State Visa Bulletin published each month. Third-party websites, law firms, and even very experienced immigration attorneys can provide predictions that turn out to be wrong because the State Department has access to data that the public doesn't have, including real-time demand information, visa usage rates, and interagency coordination with USCIS. Use predictions as a general guide, but don't make life-changing decisions based on them alone. Wait for the official bulletin. What should you absolutely not do? Don't quit your job or make major life changes based on predictions. Don't assume that just because your priority date is close to the cutoff date, you'll be current next month. The Visa Bulletin can retrogress, meaning dates can move backward, and if that happens, cases that were current can become not current again. Don't ignore requests for evidence or notices from USCIS or the National Visa Center. Missing a deadline can result in your case being denied or terminated. Don't assume you can handle everything yourself if your case has complications. There are plenty of straightforward immigration cases that people successfully complete on their own. But if you have issues like prior immigration violations, criminal history, long gaps in status, or complex family situations, you really should work with a qualified immigration attorney. This isn't legal advice telling you that you must hire an attorney, but it's practical advice based on seeing what happens when complex cases go wrong. Let me also touch on something that doesn't get discussed enough: the emotional toll of waiting for a green card. If you've been in the queue for 5, 10, or even 15 years, you know what I'm talking about. You're watching friends and colleagues move forward with their lives, buying homes, changing jobs, pursuing opportunities, and you're stuck in limbo. Your children are aging out of derivative beneficiary status when they turn 21. Your employer might be hesitant to promote you or transfer you because of your immigration status. It's a real burden. What I want you to know is that you're not alone. There are hundreds of thousands, even over 1 million people, in the employment-based backlog alone, and millions more in family-sponsored backlogs. Advocacy organizations are working on legislative solutions, though change is slow. In the meantime, focus on what you can control: keeping your documents updated, maintaining your status, staying informed, and taking care of your mental health. It's okay to feel frustrated. This system is difficult, and the waits are often longer than they should be. Here's the action plan I want you to walk away with today. Number 1, as soon as the official March 2026 Visa Bulletin is published, which should happen within the next few days, go to travel.state.gov and review it carefully. Number 2, check your priority date against both the final action dates and the dates for filing for your category and country of chargeability, which is usually your country of birth, not citizenship. Number 3, visit the USCIS website to confirm which chart they're allowing for filing adjustment of status applications in March. Number 4, if your priority date is current or within a few months of being current, ensure all your documentation is ready and up to date. Number 5, if you have questions or your case is complex, schedule a consultation with a qualified immigration attorney. You can find attorneys through the American Immigration Lawyers Association at AILA.org or through referrals from people you trust. Remember, immigration is a marathon, not a sprint. The Visa Bulletin is just one piece of the larger puzzle. Staying informed, being patient but proactive, and protecting your immigration status along the way are all critical. This process will eventually end. Your priority date will eventually become current. You will eventually get that green card. But in the meantime, give yourself grace, stay informed, and don't make decisions based on fear or misinformation. Before we wrap up, I want to remind you that Immigration News Today is here to keep you informed every single month. We'll be covering the April Bulletin, the May Bulletin, and every bulletin throughout the year. If this video was helpful to you, please hit that like button and share it with someone else who's going through the immigration process. Your support helps us reach more people who need accurate, reliable immigration information. And if you haven't already, subscribe to Immigration News Today and click that notification bell so you don't miss our next update. We're building a community of informed immigrants who support each other through this journey. Check the description below for links to official resources, including the Department of State Visa Bulletin page, the USCIS Visa Availability page, and information about where to find qualified immigration attorneys. I've also included a quick checklist you can use to make sure you're ready when your priority date becomes current. One last thing before you go. Immigration policy can change, sometimes quickly. The information I've shared today is accurate as of February 11th, 2026, but you should always verify current information with official government sources or a qualified attorney before taking action on your case. Every immigration case is unique, and what applies to one person may not apply to another. This video is for educational and informational purposes only, and does not constitute legal advice. If you need legal advice for your specific situation, please consult with a licensed immigration attorney. Thank you for trusting Immigration News Today with your immigration information needs. We know you have choices about where you get your news, and we don't take your trust lightly. We're committed to giving you fact-based, balanced, and actionable information without the hype or fear tactics. Your green card journey matters, and we're here to walk alongside you every step of the way. Until next time, stay informed, stay hopeful, and take care of yourself and your family. This is Immigration News Today, and we'll see you in the next update.